Good morning and afternoon, everyone. Thank you for joining us for our webinar at Managing Workplace Absenteeism, Legal Insights for Employers. This is the fourth webinar in our fall series, which continues to December 3rd. My name is Tala Corey, and I'm a partner at Fasken's Labor Employment and Human Rights Group, and I'm based in Toronto. I practice employer-side labor, employment, occupational health and safety, and human rights law. I work together with employers to provide holistic and practical advice. Now, before we start, I'd like to provide a land acknowledgement. First Nations, Inuit, and Métis have been present in Canada for thousands of years. These Indigenous peoples have a profound and ongoing attachment to this territory. At Fasken, we recognize that we have a role to play in the ongoing process of reconciliation between Indigenous and non-Indigenous communities here and elsewhere in Canada. We have embarked on the reconciliation journey by adopting a plan with the overall purpose of contributing meaningfully to reconciliation. Now, while I introduce our panel, please see the information that is on the screen here. I'd like to draw your attention to the survey piece. We value your feedback on our sessions and encourage you to fill in the survey before you log out of the webinar today. Today's session qualifies for a variety of credits. At the end of the session, there will be a QR code and links available to you to complete for an automatic certificate. If you don't have a chance to fill in the forms today, you will receive a certificate next week. Now, it is my pleasure to introduce our Labor, Employment, and Human Rights panel for today. Joining me is Avneet Jaswal. She is counsel in our Toronto office. Avneet maintains a broad labor and employment practice and represents both unionized and non-unionized employers. Her practice includes matters related to employment standards, agreements, terminations, workplace policies, wrongful dismissals, and related court litigation, arbitration, and accommodation issues. Joining us also is Rachel Council. She's an associate in our LEHR group. She provides advice and representation to employers on a wide range of workplace issues. She's represented provincially and federally regulated employers on wrongful dismissal claims, accommodation issues, discrimination, and harassment. And now on to our presentation. So this is our agenda for today. Our presentation will start with the legal principles animating workplace absenteeism. We will explain then the differences between culpable and non-culpable absences. Afterwards, we'll focus on one of the most common forms of absenteeism, which is medical-related absenteeism. And we'll share some information about things to do and avoid when requesting medical information to substantiate medical-related absenteeism. After that, we will talk about one of the most common ways in which to mitigate business and legal risks associated with absenteeism, and that is around building an attendance management program. Finally, we will end with guidance on progressive discipline when it comes to workplace absenteeism and the options available to employers to end the employment relationship where there has been an excessive amount of absenteeism. So we thought it would be fun to start off our presentation today with a poll. And we'll be conducting a few polls in our presentation. We love to hear your feedback and your opinion. So you can engage and participate by finding the vote button on the right-hand side of the video window in the chat bar. And when the poll appears, you can just click on the response, and that should translate into our screen here today. So I'm going to start off with a test question just to make sure that this is working. Okay, perfect. So most of you agree that today is Tuesday, November 26th. That's fantastic. Thank you. Okay, so we'll go on to our real poll for now. And we're interested to know what type of absenteeism is most common in your organization. And we've put here a few options for you. Most of them relate to medical reasons only because they appear in so many different facets, right? Short-term, long-term, intermittent. And then pregnancy and parental tends to happen quite frequently in the workplace as well. Childcare and family care reasons, we see an increase in those types of accommodations being requested. And then in the era of a hybrid workplace, we often see people arriving late or leaving early because it's easy not to police that. So I'm glad to hear that about 50% of you think that or experience short-term absences for medical reasons the most, and then shortly followed by intermittent absences for medical reasons, because most of our presentation will be focused on the medical reasons lens. Okay, so we'll start off with some general principles. Why does attendance management matter? Now, you'll be glad to hear that the Supreme Court of Canada has recognized the employer's right to manage attendance of its employees, and we've included a quote here from 2008. The Supreme Court said that employers have a management right and, in fact, a responsibility to manage its workforce. It also recognized that employers' actions or policies to monitor absences of employees is a bona fide work requirement. And that's important because it feeds into the analysis on the duty to accommodate. Now, we also know from our clients that there are other key reasons why an employer would manage attendance, and we've listed some of those on the slide. Employees who show up to work regularly and reliably, they boost operational efficiency. Employees who have minimal absences lead to more productive outcomes in the workplace. Regular and reliable attendance boosts or increases employee morale as the burdens of one absent employee are not disproportionately felt by their colleagues. And employees who have minimal absences cost the company less money. And finally, what we're going to focus on is the legal responsibility and compliance with attendance management matters. So our next slide lists the different legal concepts or the frameworks that touch on absenteeism. And these should all be kept in mind when you do deal with workplace absenteeism issues. So the first one is employment standards legislation. That includes paid and unpaid leaves. During the pandemic and since then, legislatures have been active in legislating in this area, including with respect to medical leave. So they've changed a lot of paid and unpaid leave provisions. In Ontario, most recently, I know a lot of you are interested in this development. There has been a removal of the requirement for an employee to provide a note to substantiate unpaid leave for medical reasons. On the federal level, less recently, but still in the recent past, Parliament passed or introduced 10 days of paid medical leave, in addition to 27 weeks of unpaid medical leave. The second legal framework to keep in mind is workers' compensation legislation, and that's when absences are related to a work-related illness or injury. The third is occupational health and safety legislation. That relates to the employer's obligation to ensure a healthy and safe workplace for their employees. So it touches on workplace absenteeism. The fourth, which many of you are quite familiar with, human rights legislation. This engages the employer's duty to accommodate absences, both long and short, that may relate to medical reasons, family reasons, or religious reasons. And Next, we have the three that are not related to legislation. So that would be contracts, employers' policies and procedures, and the common law. Now, in terms of the contracts, you should be looking at what your employment contract says or what your collective agreement states about absenteeism. There may be some commitments that exceed what the minimum legislative requirements are. Next is the policies and procedures that may also provide additional and gratuitous perks for employees. And finally, the common law. So, in jurisdictions that do have common law, there is a body of law that talks about absenteeism, and specifically in relation to the end of employment, when you can do it and when you can't do it, to mitigate your legal risks.
Thank you, Tala. Workplace absences are typically categorized as culpable or non-culpable absences. This distinction, which I'll explain a bit more in detail shortly, is important because it dictates how one should manage or process these absences in the workplace. So non-culpable absences are absences where the employee does not have control over the reason or circumstances resulting in the absence. So, for example, an employee that has been absent from work because of an illness or injury, because of family emergencies that may arise, absences related to statutory protected leaves, such as birth of a child, bereavement leave, family responsibility leave, and so forth. And so the idea is that an employee is not to be held at fault because these absences occur due to legitimate reasons beyond their control. And so they shouldn't be penalized for being absent from work. That's not to say that an employer doesn't have the right to manage those absences, but like I said earlier, the process in which these absences are managed would be different than in a case of culpable absences. So we'll discuss this in a bit more detail further on in today's presentation, but generally speaking, instead of disciplining employees for non-culpable absences, the focus will be on approaching these absences with the lens of support and understanding, determining the underlying reason for the attendance issues, assessing our duty to accommodate as employers, including collecting medical information where necessary and determining any accommodation needs that may be necessary, reiterating the proper procedure regarding reporting absences with employees, reiterating the employer's expectations for attendance in the workplace, as well as setting goals and next steps for attendance issues if attendance issues persist. So as I had noted before, non-culpable absences include statutory protected absences, which are protected by employment standards legislation. Currently, most statutory leaves of absences in Ontario are unpaid, with the exception of the first 5 days of domestic and sexual violence leave. Employers may choose to pay for absences related to, for example, disability, but these are usually subject to the terms of the contract. So, for example, an employer may offer short-term disability leave benefits for employees that are off due to medical reasons, but these are not mandated by legislation, but instead would be mandated by the contract with the insurer. I'm not going to expend a lot of detail on the specific types of statutory leaves of absences that exist in Ontario, but they are listed out here. And if you have any questions, feel free to reach out to us. So the slide before focused on statutory protected leaves that you'll typically find in Ontario under provincial legislation. Federal legislation, the Canada Labour Code, also has a set of its own protected leaves of absences, and they also can be categorized in underpaid and unpaid. The most recent and newly added paid leave under the Canada Labour Code is under Canada Labour Code, federal employers or employees are entitled to 10 days of medical leave with pay per year. Otherwise, typically, the types of leaves across the province and federally tend to overlap with some nuances depending on the province or federal jurisdiction. Again, these are listed out here, and I'm not going to spend too much detail, but and I'll talk about it a bit more in detail later on, but it's important to understand that these are leaves under these categories are protected under legislation and therefore would be dressed differently than you would culpable or other forms of non-culpable absences. which takes me to my next point, culpable absences. And so these are absences due to factors that are within the employee's control and are avoidable. So these absences can result in disciplinary action if they are repeated or unaddressed. For example, if an employee arrives late, leaves early, or fails to attend work without a reasonable explanation, this can be viewed as a culpable absence. An employee that is sick or on a medical related absence could be considered a non-culpable absence where an employee has failed to provide medical documentation or any supporting documentation to support the absence. And unauthorized breaks is another example. I had a case once where an employee would disappear for hours without explanation. And so they were disciplined for this conduct once it was discovered by the employer, and the employee was unable to provide a reasonable explanation for being absent 2 to 3 times a week for 3 hours straight following the lunch break. So those are situations and examples. And this is not obviously an exhaustive list, but generally the idea and the objective of culpable absences is understanding whether these absences were within the control of the employee or whether they fall within the category of non-culpable absences. Now we're going to just kind of go through a little bit of a scenario, an exercise together. So I'm going to read through this fact pattern, and then I'll ask everyone a question after, and then we'll discuss the fact pattern and how everyone responded to see how it would fall within from the objectives and the obligations of an employer in addressing these types of issues. So we have a coworker who informs you, the manager, supervisor, that an employee, Sam, has been leaving work early repeatedly and logging her time incorrectly. The coworker warned the employee that employees have been fired for this behavior before, but the employee continues down this path. You initially, as the supervisor, do not intervene because you want to protect the confidentiality of the person that raised this concern to you in the first place. However, you later catch Sam red-handed yourself, incorrectly logging her time and suspend her. During the investigation, Sam first denies logging her time incorrectly, but then later admits to leaving early due to a family emergency and expresses immediate remorse. So I'm going to ask everyone to participate and answer the question as to whether there is cause to discipline or terminate Sam for her conduct. I feel like people are still answering, so I'll give everyone a few more seconds before I move on. Okay. So, I think it's teetering around this number. So 82% of the participants today think that, yes, there is cause to terminate or discipline, and 17% feel that there is no cause here, or 16%. So this fact pattern is actually from a decision in an arbitration case that was decided in 2006. The arbitrator ordered that the employee in this case be reinstated. So she was terminated for her conduct and grieved the termination. It was a unionized setting. And so the arbitrator ordered that this individual be reinstated to her former position and instead imposed a suspension that started from the date of her termination until the date of the decision. And the suspension was unpaid. So she was not ordered any back pay. In deciding and arriving at this decision, the arbitrator considered a number of factors. So in this case, the employee came across as credible and accepted responsibility, not only during the hearing, but as well as immediately when she was, or shortly after she was confronted by her supervisor in the workplace. And she showed remorse when questioned. Another factor that was considered was the fact that the employer did not apply progressive discipline. There were no lack of prior warnings, and there was also a degree of condemnation that came into play here because the supervisor knew she was doing this but did not intervene sooner, and instead waited until they witnessed it themselves before taking any action. There were also mitigating factors, so factors that the arbitrator looked at in deciding a lesser penalty than termination, and that was the legitimate personal circumstances of this individual and the fact that she was apologetic and showed signs of rehabilitation. So I think in this situation, everyone, pretty much 86% of you answered fairly correctly because at the end of the day, while termination was deemed too egregious of a penalty, given some of the mitigating factors and the conduct of the employer in addressing the situation, the arbitrator did agree that this behavior warranted some degree of discipline. And so the individual did end up being suspended for quite a bit of time without any order of back pay.
So as Avneet mentioned, the explanation and the reason for an absence is going to be really key in an employer's decision for how to manage that absence. And one of the things that we saw in many of the questions that were submitted beforehand for this presentation is a lot of interest in how to manage and accommodate medical absences. As Avneet mentioned, absences for legitimate medical reasons are considered to be a form of non-culpable absence, which can be subject to discipline. And they can also trigger a duty to accommodate. And so this next section is going to be focused on recapping those general legal principles and how they apply in your workplace. What I'm interested in knowing first before we get into it is, in all of your experience, what type of medical accommodation you find yourselves most often granting employees and who are absent due to medical conditions. I'll let us go for another couple seconds, but it does seem like right now modified duties and potentially modified hours of work and schedules appear to be the most popular form of accommodation. And that makes sense to me. It can be a fairly direct and frontline approach from employers that hopefully don't impact the operations of your business to the degree that a more long-term leave of absence or potentially, remote work might have. Okay, very interesting. So just to recap some of the legal principles that are going to underpin our analysis here. Obviously, accommodation, as all of you know, is going to be a core part of your attendance management process. Human rights legislation in all provincial jurisdictions, as well as in the federal jurisdiction, prohibits employers from treating employees adversely on the basis of any protected ground, including disability, religion, family status, etc. And they also impose a duty to accommodate employees on the basis of those grounds. Today, we're going to focus on disability and medical accommodations. And the key focus here, of course, is that an employer cannot penalize, discipline, or terminate employees for taking leaves of absence due to disability, or to provide care for a family member with a disability. And in order to fully be able to apply this, we have to understand what counts as a disability and falls under the protection of this human rights legislation. First off, the definition and the scope of the term disability has evolved in the case law over time. And so we know today that disabilities include both visible and invisible disabilities, mental and physical components. But human rights decisions have also interpreted the definition of disability as including the fact that a person used to have a disability or is perceived to have a disability, even if they are not, in fact, currently disabled. And as our human rights law evolves, so too is our understanding of what is captured by disability, including fibromyalgia, chronic fatigue syndrome as some examples, substance use disorders, eating disorders, and pregnancy loss. As our case law develops and these facts come out, tribunals are always given an opportunity to sort of renegotiate and reconsider what will count as a disability in the workplace. And so we thought it would be helpful to include a couple examples of disabilities that have been recognized in the legislation. I've put them up on the screen here, and I'm not going to read them out in full, but I did want to note that physical disabilities can be permanent or temporary. They can also be episodic, and they can also be progressive. And so, there's a whole range of medical conditions and potential physical disabilities that employers have to grapple with in their workforce. And I think one of the biggest questions when we think about this is what are the limits to the definition for disability? And what I would say to that is human rights tribunals have consistently held that commonplace temporary illnesses that are short-term, that are not chronic, and that do not significantly impair an individual's ability to perform their duties will typically not be considered disabilities that require accommodation under human rights legislation. And so the easiest examples of this are if we come down with the cold or the flu, or we are recovering temporarily from a surgery, that usually will not be considered a disability. That being said, it's easy to imagine where these lines get a little bit blurry. So for instance, if a temporary illness results in some sort of long-term, significant or recurring impairments, I'm thinking maybe most topically about what people call long COVID, or the psychological effects that are associated with an illness, complications from a surgery that might result in long-term impairment. You can really see some examples where a tribunal might take a different approach to what otherwise might just be, a cold or a flu. For example, a couple years ago, the Ontario Human Rights Tribunal recognized pregnancy loss to be a disability on the basis that it is not a commonplace or a transitory illness, which might be surprising to some, but the tribunal indicated that it was very clear that there were significant psychological impacts associated with the pregnancy loss that impacted the particular employee, in that case, their ability to work. And I think that's a good transition into our slide with some examples of mental disabilities. Mental disabilities, of course, they're going to pose particular challenges for employers due to their invisible nature. And of course, we have to recognize the stigma associated with mental disabilities that still exists in some workplaces. Employees might be reluctant to seek a diagnosis, treatment, accommodation due to that stigma. And so, but we do have to recognize that the rate of mental illnesses worldwide and in the workplace is, of course, increasing with more acknowledgement of these types of issues. And so I simply raise all of this to remind us that these concepts should be in the back of our minds when we are evaluating absence requests, when we are dealing with employees in the workplace. It is always best to be cautious, to obtain reliable information, and to determine whether an employees' attendance problems might actually be related to a physical or mental disability that might require accommodation. Along those same lines of obtaining reliable information, it's also important to recognize that there are some things that may not amount to a mental disability. And here I would say that bare assertions of stress or anxiety or depression without a recognized medical disability, working diagnosis, or clinically significant symptoms will also not be protected by the code. Again, this is a thin line for employers to draw, and we are going to spend some time in this presentation talking about how we suss out and obtain that reliable medical information. But we do get some guidance from the case law on this as well. I'm going to quickly talk about a municipal labor arbitration case from a few years ago where an employee claimed that he could not drive a company-owned smart car due to anxiety associated with driving small vehicles. So he sought accommodation in the form of being able to use his own vehicle for his work-related duties. And what the employer did instead is provide interim accommodation to this employee and say, you can work at a desk job for the time being while we ask for further medical evidence of your mental disability. Eventually, that included a request for independent medical examination that the employee refused to cooperate with. And his union eventually brought a grievance for this alleged failure to accommodate. Now, in this case, the arbitrator ended up dismissing the grievance on the basis that the griever hadn't established that he had a disability relating to anxiety, because the medical documentation was relatively thin. It was based on his own reporting as opposed to a thorough assessment from his treating physicians. He refused to agree to an independent medical examination. And of course, as there often is, there was evidence that this griever had initially just refused to drive the smart car based out of his own personal preference. And it was later found that he had also engaged in riskier activities of the same type that he had claimed anxiety over, including flying small planes. So all of the evidence in that case established that the griever did not have a medical disability that needed accommodation. And the arbitrator found that the employer hadn't failed to accommodate. The takeaway from this case study is that there may very well be cases where an employee's claim that they're suffering from a mental health issue or mental disability that prevents them from performing their duties is not supported by the medical evidence. But it is clear in all cases that due diligence from employers, including providing temporary accommodations while an investigation is unfolding, is going to be very important. It's crucial that we do not jump to conclusions. Okay, so what is the accommodation process? What does the duty actually require? At its most basic, the duty to accommodate means that employers need to adapt the workplace so that they can enable employees with disabilities to participate in employment. The duty to accommodate is only triggered for needs that are actually known. Of course, employers are not, as a rule, expected to accommodate disabilities that they are not aware of. The obligation is on the employee to communicate the nature of the disability that they are claiming to the employer and raise the need for accommodation. I say all of this, but a duty may also arise when an employer knew or ought to have reasonably known that the employee was suffering from a disability. And we see this coming up a lot in the case of mental health issues. This duty, which is a duty to inquire, recognizes that some people may not be able to disclose or communicate their needs because of the nature of their disability. So if, for example, an employee is suffering from a substance use addiction and they do not seek accommodation from the employer, but the effects of that addiction are obvious to the employer, there is a positive duty on the employer to proactively try and offer accommodation, provide the employee with opportunities to identify an accommodation need, and effectively make further inquiries. I say this, employers are not expected and they should not try to self-diagnose or second guess the health status of an employee, but the goal is to make sure that employers are being proactive in offering that accommodation in the event that there is a need. And so instead of saying something like, are you sick? You don't seem yourself lately. You might say, I've noticed that you've have increased absences lately. Is there anything affecting your ability to attend at work that we need to be aware of? And do you have any accommodation needs? Once the duty to accommodate is triggered, so once we have identified an accommodation need, what does accommodation require? Well, accommodation is an individualized analysis. It has both a procedural component and a substantive component, so process and result. The procedural duty involves considerations, assessments, and steps taken by the employer to respond to the request or the need. And so the employer needs to take documented and significant steps to consider how it can accommodate an employee. And this has to be a meaningful process. And decision makers, human rights tribunals are going to review the process that the employer took and the communications it had with the employee when it considers whether or not there has been a failure to accommodate. The substantive duty, of course, is going to be about the reasonableness of the chosen accommodation and the reasons for not providing an alternative accommodation. So, including proof of undue hardship. And what this means is essentially that an employer is required to accommodate employees to the point of undue hardship on the basis of a protected ground. So once the need is identified, employers need to take every reasonable effort short of undue hardship to accommodate the employee, unless they can prove that the workplace rule that is impacting the employee is a bona fide occupational requirement. The B4 test, as lawyers like to call it, is a standard that is integral to carrying out the requirements of the job duties. And so it's part of the essential duties of this employee's position that they abide by this attendance policy, for instance. And we would have to prove that for any accommodations or changes to that standard would result in undue hardship. If we can't prove that, then there is going to be a requirement to accommodate that employee up to the point, again, of undue hardship. And so this is an important threshold. It is also a high threshold, and a variety of factors are going to be considered, including financial hardship, safety, security, and other practical constraints that might prevent an employer from providing a particular accommodation. Of course, in determining what is undue hardship, the case law is clear that both employers and employees need to work together to find a solution. And so everyone needs to be open to a variety of creative measures of returning the employee to the workplace. Employees should not expect a perfect solution, and it's important for employers to remember that they do not have to provide an employee with their preferred solution, just reasonable accommodations. That being said, you still do need to consider the wide range of options available to you. And when we think about undue hardship, there's a lot of things that might not meet that standard that may be surprising. So, for instance, a preference to maintain existing processes, avoid change, continue with business as usual practices is likely not going to be enough. Human rights tribunals and decision makers expect employers to change and modify their policies when necessary to accommodate employees to the point of undue hardship. So minor administrative inconvenience or disruptions to the business may have to be tolerated, including some level of absenteeism, of course, based on the facts and in the circumstances. Employers also can't claim undue hardship simply because an accommodation costs them money. So the financial burden, while it will be a factor and is certainly something to consider, it will be assessed relative to the organization's resources and the size of the organization. And it may be that a decision maker finds that a one-off cost is something that the employer should have to bear. So as a really quick recap for this section, before we move on to evaluating medical information, employers have certain responsibilities under the duty to accommodate. They need to inquire where necessary. They need to collect relevant information and follow up within limits that we are going to discuss. They need to conduct searches for accommodation options. And again, we encourage employers to be creative and to engage in robust searches for different accommodation options, and then offer and implement that accommodation and work with employees to do so. Practically speaking, it's important to make sure that you are documenting and holding meetings with employees and managers as you explore accommodation options. Try to be flexible, but also make sure that everything is communicated expressly and followed up on and documented so that we have evidence of the efforts that the employer has made to fulfill its procedural duty to accommodate. And especially when we're evaluating the appropriateness of accommodation, it's important to think about what evidence real tangible evidence we have and we can collect to show that accommodation is impossible or would lead to undue hardship, or why an employee's requested accommodation is less appropriate than the very reasonable accommodation that the employer is offering. And on the flip side, employees also have obligations to cooperate in the accommodation process. Accommodation is very much a two-way street. When unions are involved, they are a three-way street. Employees are required to advise employers of their need for accommodation, provide and be responsive to information requests, provide suggestions, give employers reasonable time to search for accommodation options, and also to accept offers of reasonable accommodation. Again, employees are not entitled to their preferred form of accommodation. Employees are also required to keep employers updated if there are changes in their accommodation needs. So it is very much a process that all parties have to facilitate. And we're going to dive into that a little bit deeper.
Okay, so our next topic is about requesting medical information. So the first question that we should be asking ourselves is, when can an employer request medical information? Now, tying back to the legal framework that I mentioned at the outset of the presentation, you'll see some of those principles outlined here on the slide. There's three conditions. The first is that the statute allows requesting medical information. The employer, number two, the employer has a legitimate work-related purpose to request the medical information. And then number three, the collective agreement or employment contract permits the employer to request medical information. So if the statute does not permit it, but it is permitted, let's say, by the collective agreement, you still, it may be still difficult or impossible for you to ask for that medical information because it is prohibited by statute. So while all three conditions must be met, there are ways in which one or two may be sufficient. Now, in terms of the next slide, we've highlighted a few legitimate work-related purposes to request medical information. And those are the situations in which it would be helpful to get that medical information to ensure that you are meeting all of your legal obligations, including your duty to accommodate. So depending on the purpose for which medical is needed, the employer can determine how much and which information you ask for. The idea is to have a plan in place regarding the request. And in formulating that plan, it is important to keep in mind two things. First, why do you need this information? And number two, do you already have some information and is that information responsive to what you need? So here you can see some of the work-related purposes answering question number one in terms of why you would need the medical information. In terms of the second part about the whether you do have already some information, that may be relevant for when you're requesting a follow-up or a clarification. And we'll touch on that a little bit later. But employers should be cautious when asking about medical information because you may already have suitable medical information going back for that legitimate purpose. And so going back for more may unnecessarily complicate matters. I see we have a question in the chat about if employers can ask for medical notes if the sick days are paid by the employer. And the answer is that if you're providing a benefit over on top of what is the minimum requirements in employment standards legislation, then you may ask for a medical note to substantiate not the absence, but the entitlement to the pay. And so there's that differentiation that you must make, and it would be advisable to include that in the request that you're making in writing. And so should a medical note not be forthcoming, then the employee would still not be penalized for the absence if it's within the confines of the employment standards legislation in terms of the number of days, but they may not be paid.
Can I one thing, and thanks, Tala, just to that question. I know that there's been recent changes to the ESA with respect to prohibition on asking for medical certificates from a qualified practitioner if the employee is exercising their right to the 3 sick days that they get under the ESA. So in that case, I think the clarification is that an employer is not disentitled to ask for support. It's just the legislation has said, and to Tala's point before, that an employer is prohibited from asking for a certificate from a medical practitioner, but they can still ask for support. And to Tala's point, if an employer, let's say, provides 10 paid personal days or sick days to an employee, as long as it's outside the 3 minimum entitlement days that they're allowed under the ESA, an employer would, arguably in those circumstances, be allowed to ask for supporting medical information because they're providing a greater right or benefit that's not legislated.
Thank you, Avneet. So moving on into what kind of medical information employers can ask for. We've included here a list of the medical information that you may ask for and the medical information that you may not ask for. Again, having a plan in place to determine whether you need all of this information or whether you need only a portion of it would be helpful. So I'm sure all of you know that employers cannot ask for diagnostic information, but you can ask about functional limitations. You can ask about the duration of the limitations, how they impact the job duties, the timeline for further assessment, and the prognosis. There is even some case law suggesting that the identity of the treating physician or their specialty is not something that should be disclosed, as that may give away the nature of the medical condition. But that's sort of, there's mixed case law on that one. Now, the corollary of the employer's right and duty, in fact, to ask for medical information to substantiate absences or other medical conditions is that the employee has an obligation to provide that medical information. That is a positive obligation under the law. And the obligation is to provide sufficient medical information to either justify their absence or justify their request for accommodations. In certain circumstances where an employee has failed to participate or failed to respond to the employer's reasonable efforts to get that medical information, then not only is the risk of a liability in terms of accommodation mitigated, but the employee may even be subject to discipline, again, in certain circumstances. And that discipline would not offend either employment standards legislation or human rights law. Now, I'm sure many of you have gone through the process of requesting multiple medical notes from a single employee to substantiate a long-term absence. Even though it was one of the less frequent or less common types of absences that you've seen in your organization. But again, I go back to the plan. As part of your plan, in determining which information to ask for, consider whether this is the first time that you're asking for medical information, or whether this is a request for clarification, a request for follow-up, or a second or subsequent request for information. Again, keep in mind the purpose for requesting that information. For example, in the first instance of requesting medical information, you may be only interested in the projected duration of the absence, and whether there will be anticipated functional limitations upon their return, right? But for a prolonged absence, in the second plus ask, you may need to know some more detailed information about prognosis, right? How long is this person going to be off? What do I need to do on the back end to address business needs? Is this a position that I should be posting out or filling on a temporary or permanent basis? Some of the questions, some of these business-related questions may inform the type of medical information that you ask for. Now, in even longer absences, you may start setting yourself up for frustration of contract by asking whether the employee will be reasonably expected to return to work in the foreseeable future, and then building up that evidence to ultimately end the employment relationship on that end, if you do get the medical information that allows you to do so. We've seen this a lot with our clients coming back with insufficient medical information. Some of it is, we recognize that our healthcare system is overburdened and overworked. And so sometimes, through no fault of their own, medical practitioners do not complete a questionnaire fully, or they answer the question that they want to answer as opposed to the question that we are actually asking them to answer. And so this type of situation where you do get insufficient medical evidence because of either a non-responsive answer or information coming back because it is old or very dated, then that would require the employer to request updated or clarification medical information. And now I recently dealt with an issue where an employer requested a clarification and follow-up in, let's say, October, and the employee just resent the original functional abilities form from August. And so, that type of stuff you should be following up on to clarify the medical information. And the gold standard in doing that, or what we advise in doing that, is to document your efforts to get that additional medical information or that clarified medical information. And in that written request, we suggest 3 things: reiterating the information being requested, being specific about the information that is needed to move the matter forward, confirming that the employer is entitled and has the right to receive this information, and third, reaffirming the employee's obligation to cooperate. Right? So all of these general principles just to set the stage and make sure that all the stakeholders involved know what is at issue and how best to support the employee and the employer in moving forward. Now, in terms of prolonged absences, we've included here a slide on tips or best practices to dealing with those. Ideally, the organization would have 1 point person or a point person per business, depending on the size of your organization, to manage those prolonged absences. So that person, and they could have other duties and responsibilities, but it would be one dedicated person because they would be responsible for following up periodically with employees who are on prolonged absences to ask for updated medical. These follow-ups should be made in writing, and that follow-up should include all of the information that I just mentioned. So what is the information that we need? From whom do we need this information? And then reiterating the employer's right to receive that information and the employee's obligation to provide that information. The written request could also place a responsibility on the employee to advise of any material changes regarding their condition or their ability to return to work. So that again puts them in a position to take ownership over their obligations and their journey to return to work. Now, you'll see here in the slide that we've said periodic follow-ups, and many clients ask us, well, what frequency should that be? What do you advise? There is no bright line requirement on timing. It's the classic lawyer response of saying, it depends. It is a contextual approach that I would recommend based on the facts of each case. So, if you find that based on the information that you're getting, there doesn't seem to be a lot of movement, then you can extend the period of time during which you ask for follow-up. And sorry, I should clarify, movement as in movement in terms of prognosis. You can extend the period of time to request follow-ups. But generally speaking, my experience with clients is that the follow-up is generally between 3 and 6 months. The last slide in this section is about privacy considerations. And we've included that because we're talking about medical information here. There's a lot of medical privacy requirements, legal requirements that employers must abide by. And so here are some of the tips to keep in mind. Some of them are maybe obvious to you in terms of keeping a separate file with the medical information separate from a personnel file, limiting access to people who need to know only, using the medical information for the purposes for which it was collected, and not releasing it without employee consent. Now, this may be relevant for organizations that do not have a separate occupational health and safety department, or a medical professional like a nurse or a doctor that houses that information. But again, those principles would similarly apply in in a specific subset of the human rights department, the HR department that would deal with these types of issues. On the federal level, you should also be aware of your obligations under PIPEDA. And on the provincial level, there are some jurisdictions where there are specific privacy requirements to keep in mind. Now I'll hand it over to Avneet.
Thank you, Tala. We're going to shift gears a bit now, and we're going to talk about the various ways that employers can address attendance in the workplace. This can be through wellness programs where employees are provided with support and information to assist in their care and maintenance of their health and well-being, to hopefully, in turn, foster good attendance in the workplace. Employers can also provide training to employees, specifically to management and supervisors, on how to handle and approach attendance in the workplace, when to reach out for support, when to request medical, and when to intervene and address potential concerns, and how to communicate these expectations with direct reports. And finally, employers can develop formal attendance management policies that deal with attendance issues in a consistent and formalized manner. So attendance management programs are a useful tool in addressing workplace absenteeism. These policies will typically outline the expectations in relation to attendance and how it will be handled in the workplace when an employee fails to meet these expectations. And it's always important to understand that the ultimate goal of an attendance management program is to reduce absenteeism and improve overall attendance, but at the same time provide support to employees by identifying any underlying health and personal issues affecting attendance. When implemented appropriately, a lot of times these policies can be a useful tool in intervening at the right time to correct attendance and identify issues early on. So they can be very important in the workplace when applied properly. the goal of attendance management programs are also to improve productivity, to ensure that workplaces are operating at an efficient manner and with minimal disruptions. And also having a formal policy that is applied and consistently will ensure that employees have a clear understanding of the expectations of them and that they are treated fairly in adherence to those established policies. Typically, most attendance management policies will be comprised of a number of key elements. And a majority of the policy will be addressed at understanding and how attendance and absences will be monitored. So these policies will include information on how employee absences will be tracked, how culpable absence will be treated versus non-culpable absences. If you recall, earlier on in the presentation, I had mentioned that culpable absences will follow a different process and path than non-culpable absences, given that culpable absences can be disciplined. These policies will also outline key thresholds that will trigger steps within the attendance management program. So, for example, if the policy may outline that X number of absences, let's just say 10, will result in a period of time. So, for example, in 6 months, will result in an employee commencing into the program. And then there will be additional metrics that exist in the policy that will identify when an employee may progress up within the program should they continue to have poor attendance. It's important to note when dealing with non-culpable absences, the goal of an attendance management program is to support an employee, provide clear expectations, and assist them in improving their attendance in the workplace. These policies are not designed to be punitive in any way, and instead are there to help identify patterns or trends in absenteeism that can potentially be addressed early on enough to provide the necessary accommodation to hopefully cure or improve the absences. Time and time again, I've seen these programs, when appropriately applied, address concerns early on by providing employees the necessary support. For example, I had one case where the application of the attendance management program resulted in a small tweak in the schedule to improve attendance for a particular employee. So they can be very useful when they work. So another step or factor that will be found or common in an attendance management program is the stages or steps that an employee will go through ultimately in the program. So there will be multiple stages. I've seen anywhere from 4 to 6 stages where an employee will have to meet a certain threshold to enter stage 1. And then there will be metrics that an employee has to meet or will meet in order to progress through the program or come out of the program. So usually stage 1 is designed or reviewed as the initial monitoring period. And after a certain threshold of absence is exceeded, an employee will enter into this stage. In stage 2, or the next step, an employee will be monitored again over a certain period. And should they meet the threshold for that stage, then they would progress and continue in the program to the next stage, and so forth. And as you progress through the program, the level of involvement and the type of medical information and supporting information that may be needed from the employee may progress as well and become more involved on both sides. And then finally, at the final stage of a program, often it will involve a formal meeting and potential disciplinary action, depending on whether the person was through the culpable or non-culpable process. And then another factor of an attendance management program would be, like I had mentioned before, the intervention and support. And so throughout the program, there will be elements designed for the employer management to be able to intervene, provide things such as counseling, medical assessments, adjusting and kind of triggering the accommodation process to adjust working conditions, and all aimed to identifying any underlying issues that the employer can support to help provide solutions for the attendance issue. There will also be a clear communication element for the program. And so usually this may be in form of a letter, sit-down meetings, but the idea is that the employee is continually spoken to or communicated with respect to where they are at the program, how they're doing, and in an effort to create a level of transparency and support so that the employee can hopefully understand the expectations of them and reach out for support and help when needed. And then there's the element of documentation and records. And I know Tala went through in detail of what these documents and records can look like, but essentially, if there's an element or requirement for an employee to supply documentation to support absences after a certain stage or after a certain number, these will typically be outlined in the attendance management program. So when developing an attendance management program, determining the thresholds and stages must be unique to the workplace in question. The idea is to set up employees for success and not failure. So employers can rely on a myriad of factors to determine a reasonable threshold for entry and progression. This does not have to be a perfect analysis, but the idea is that it should be reasonable and catered to the workplace or organization in question. So a lot of times employers will use things like average absenteeism rates for the group in question. So for example, if employees average 7 absences per year, then the number that is developed to determine the triggering threshold into the attendance management program may be something that is in line with that average or taking that average into account. Another very important pitfall is failures to apply discretion. While consistency is key to ensure a fair application of the policy, this must be balanced when using discretion to ensure employees are being treated fairly based on their unique circumstances. I know there was a significant discussion on workplace accommodation obligations for an employer, and so it is very important that we are recognizing the types of absences that exist and applying the correct obligations as an employer to addressing those absences. And this kind of takes me to my next point, where on some pitfalls or gaps that we may see in attendance management programs, and that's the idea that the attendance management program is not designed to replace an employer's duty to accommodate. In fact, time and time again, adjudicators and judges have confirmed that disability or other statutory protected absences, so for example, disability protected absences under the human rights legislation or parental leaves, workers' compensation related leaves, cannot be counted towards an employee's absences under the attendance management program. The idea here is that these absences should be managed separately because they include certain other legislated obligations to the employer and may not fit squarely within the stages and steps of an attendance management program. That's not to say that these absences shouldn't be managed, just the idea is that they should be managed separately in line with the employer's obligations under the respective legislation. So the outcomes of an attendance management program there are a number of them. And so for non-culpable absences, it can take time to get to the point of frustration. And many considerations must apply before we get there. But it is always recommended that when you're at the final stage of an attendance management program for a non-culpable process, that supervisors or human resources seek advice and counsel to determine whether the relationship has truly been frustrated. As Rachel had pointed out, that employers have a duty to accommodate to the point of undue hardship, and non-culpable absences could fall under that duty. And therefore, there are a myriad of factors that need to be considered when determining whether the employment relationship truly has been frustrated. But like I said before, the outcome is designed for non-culpable absences to provide support and accommodation and recognize where support can be provided and hopefully correct the absenteeism issue early on. And if it's not correctable, and to Tala's point in the beginning, management has the right to require its employees to attend work and perform the work that they've been hired to perform. And so ultimately, if the employee progresses all the way through the attendance management program, through the non-culpable stream, you could get to the point of undue to frustration of contract or employment of the employment relationship. Also, I know I noted before that disability-related absences must be managed separately, but where they come into consideration in the form of in the context of an attendance management program is the fact that they can be reviewed as to apply holistic approach when determining whether the relationship truly has been frustrated, and taking into account the employee's absence as they relate to disability, as well as absences that have been exhausted through the attendance management policy. And therefore, a holistic approach can be applied to determine if both under the policy and human rights legislation, the employee's relationship has been frustrated. And then for culpable absenteeism, the goal of it, an outcome of the AMP is to eventually lead to some form of disciplinary conduct or dismissal, because absences that are within the control of the employee and therefore should be managed through that performance management discipline stream. So when applying attendance management policies in the workplace, there are a few key best practices that we typically like to advise employers, and that's to be on top of attendance and review attendance records and absences and reasons for those absences. I know a lot of times, sometimes a supervisor may mark an absent, but fail to ask the employee the reason behind the absence. And so then when you're going back and looking and reviewing all the absences that the employee may have had during a certain review period, we're unable to determine or distinguish whether these absences were culpable, non-culpable. So it's important that supervisors and managers are trained to manage absences, record absences, and ensure that they're recording the reason for the absences. And another important best practice is ensuring that the employers meet with employees who are under attendance management policies or programs and discuss concerns early on. So if there's a pattern that's been established, an employee, for example, is absent every Friday before a long weekend, there's a pattern there. You want to intervene early enough once the pattern is identified and have communication and direct contact with the individual to understand if this is legitimate or culpable versus non-culpable, and what the next step should be in that process. You want to be able to make sure that we're keeping track of the number of incidences and the length, for example, and applying the correct approach depending on the type of incident and the length of the absence. So one incident of 20 days due to, for example, an employee may have gotten a minor surgery, and so they're absent 20 days straight, versus someone who has 20 days of absences, but on separate days throughout a period of 6 months. Those two may be managed differently. And again, to Tala's point, a contextual approach must always be applied when addressing these types of absences in the workplace. And always seek guidance when unsure. We often get involved in circumstances, and whether that's human resources internally, internal counsel, or us as external counsel, as a reactionary step versus a preventative step. And there are a lot of things that can be done to help mitigate risks as these types of issues progress, or take steps that will help ensure that we're applying a consistent approach. And so we really always encourage, when unsure, always seek guidance. And whether that's from your internal human resources department, internal counsel, or external counsel, there's sometimes a quick fix or a quick answer to something as a proactive step versus a reactionary step. And finally, I just again want to reiterate the idea of applying a case-by-case approach within the parameters and consistency of an attendance management policy. So yes, they're there to ensure that we are uniformly applying the policy, but they're a contextual and there must be the ability to tweak how the policy is applied depending on the unique circumstances of each individual. I think a second important point is ensuring that managers and supervisors are appropriately trained on the company's attendance management policy and how it should be applied. A lot of times, they are the first point of contact in identifying employee absenteeism. So if they are not aware of the policy or how it should be applied, those are missed opportunities as an employer to appropriately manage these absences. And again, no two situations are the same, and therefore always just keep that in mind, and when in doubt, ask. I'm going to now hand it over to Rachel, who's going to speak next about progressive discipline and how it can lead to the end of the employment relationship.
Thanks, Avneet. And I think it's a good way to use the last 15 minutes of our time here, because I can see from all of the questions that have been coming in during the presentation that we have a lot of questions about when and how and under what circumstances we can end the employment relationship. And so the lawyer answer is that it's going to depend based on all of the facts. And I can see from all of the different, very unique factual circumstances in the questions that, it's a case-by-case assessment. But what I'm going to do is review the legal concepts for all of the different types of ending the employment relationship and the different approaches that you can take. And hopefully that can provide some guidance when you are applying it to the specific facts of your situation. So the three approaches, specifically when we're dealing with absenteeism, that are most common are frustration of contract, job abandonment, and of course, just cause for dismissal. Moving quickly along here, we're going to deal with frustration of contract first. As we've indicated previously, and as Avneet just expanded on, frustration of contract is available for non-culpable absenteeism. Particularly, we most often see in the form of an employee's prolonged absence due to illness and injury. The right to terminate an employee who is absent due to illness or disability comes from the doctrine of frustration. And this is a legal doctrine that says that a contract is frustrated when circumstances beyond the control of either party to the employment contract creates a situation where it becomes effectively impossible for the contract to be performed as originally intended. And so when you think about the case of an employment contract, the employee agrees to perform work of the duties of their job in exchange for compensation. And disease or disability may prevent an employee from discharging those duties. And so the key question here is whether or not there is a reasonable likelihood that the employee will be able to return to work and perform the essential duties of their job in the foreseeable future. And there's a couple moving parts to this test that we have to think about. And because I will say at first instance, because this is a no-fault way of unwinding the employment contract, that will result in the employer not having any obligations to the employee beyond their minimum entitlements under the applicable employment standards legislation. There is going to be scrutiny that is given to employers who are trying to justify the end of a relationship due to frustration. So this is a high bar to meet, and employers do have the burden from an evidentiary perspective of meeting that threshold, this reasonable likelihood that the employee is not going to be able to return to work for the foreseeable future. So what are the factors that go into this assessment? The nature and expected length of the illness, the employee's prognosis for returning to work, of course, like how long they've been employed and how long they've been off work. And the thing I want to emphasize here is that there are multiple factors that go into this test. The mere fact that an employee has been off work for a prolonged period of time is not in itself going to be determinative of whether the contract is frustrated. And the fact that an employee has been out of work for months or even years is not going to be the only thing a decision maker takes into consideration. And so I saw a couple questions that asked, like, how long is long enough? And unfortunately, the lawyer answer I'm going to provide is that it really depends on the circumstances. It depends on the nature of the job and the nature of the employee's illness. And I think the most effective evidence that an employer can provide to establish frustration is medical information that suggests that the employer or that the employee is unlikely to return to work in a reasonable time frame in the future. And so we're looking at actual medical documentation that says, this employee is permanently disabled and their disability prevents them from performing any of the essential duties of their position. Or this employee's prognosis is so poor that we don't expect the employee to ever recover to a point where they can return to work, or that it'll take, 3-4 years for that to happen. And I don't mean to suggest that you have to allow employees to languish on leaves of absence indefinitely for years and years, but I do suggest that employers make sure that they are keeping track of their employees who are on these prolonged absences, keeping in touch with them, requesting updated medical information, including asking questions about the employee's prognosis, so that in the event that that medical information comes back from the treating physician with a prognosis that says they are likely not going to be able to return to work within a reasonable period of time, the employer then has some evidence and information that they can rely on for frustration. Other factors that go into this are going to include like your organizational capacity, your operational needs, this particular employee's duties, and whether or not, their illness and their absence to date has rendered their particular employment contract impossible to perform. This next slide is essentially a little checklist for employers to follow. You need to consider all of these items before you move to frustrate. And the one thing I will highlight here is the duty to accommodate. Again, every one of these options for ending the employment relationship is going to be informed by the accommodation principles that we discussed earlier. And so we always need to make sure that we are complying with human rights, employment standards, and workplace compensation legislation. Okay. Moving on to job abandonment, I saw a couple questions that were relevant to this as well. In some circumstances, job abandonment is going to apply where an employee is absent from work without authorization and is also acting in a way that suggests that they don't intend to return to work or cooperate with their employer in the return to work process. So job abandonment isn't going to be just an absence, but also an implied resignation. And the legal test is going to be very similar to a resignation test. So here we have the key question. Are the statements or actions of the employee viewed objectively by a reasonable person a clear and unequivocal indication of an intention to no longer be bound by the employment contract? Some common scenarios where this might happen is if an employee has left work due to an illness or injury, but has continuously and repeatedly not complied with an employer's attempts to maintain contact with them throughout their absence, to provide sufficient medical information, and a general disregard for the employer's absent management or accommodation process. Or if, for instance, an employee has failed to return to work after an approved absence, like a vacation, and converting that into a prolonged unapproved leave. I saw another question that is captured in this slide where an employee has relocated without telling their employer. Because job abandonment is going to be determined based on a culmination of actions by the employee, we're always going to need to rely on this kind of circumstantial evidence. And so it's important to make sure you're documenting the social media posts that you see of the employee, somewhere that they're not supposed to be. You need to make sure that you're investigating that and following up. And that's essentially what I've set out in this slide. We always recommend that employers make multiple attempts to contact the employee through as many channels as are available to the employer if an employee is not responding to the employer's attempts at communication. We also recommend that employers provide formal warnings, usually in the form of repeated follow-ups through registered mail, through letters, that we can prove reach the employee and provide them with a reasonable opportunity to respond to the employer's requests. And only after those final warnings have been provided, and only after we've provided employees with warnings of the consequences to their employment relationship if they do not respond, do we recommend typically that employers move ahead with asserting job abandonment. The only other thing that I would consider here is that you need to consider potential explanations for the non-communication. When you think about how the duty to accommodate and the potential for there to be a disability informs this process, disability could impact an employee's ability to communicate with their employer. A medical emergency or a family emergency could impact this ability to communicate. And so employers do have an obligation to make sure that any of those potential explanations, potential non-culpable reasons for their absence are explored and the duty to accommodate has been met. And so in all of these cases, you want to avoid premature assumptions, and you want to make sure that you are exploring accommodation needs if they arise before you move to terminate for job abandonment. And finally, what can employers do in situations when the employee is experiencing excessive culpable absenteeism that impacts the workplace, but they're communicating with their employer, for instance, so they haven't abandoned their job? Well, employers can always terminate for just cause, including for reasons of performance and culpable absenteeism. But as you all know, this is a very high threshold that is only getting higher as the case law continues to develop. Just cause for poor performance, including poor attendance, is going to be difficult to establish without evidence that the employer engaged in progressive discipline prior to resorting to termination. And so don't assume that you have cause. Make sure that you are considering all of the facts and all of the circumstances. And I think most importantly, ensure that you are engaging in progressive discipline. I've included some examples on this slide of different factors that could inform the just cause analysis, including, any factor that tends to suggest that the employee is actually acting intentionally or willfully. So that's going to be considered definitely more serious conduct than an employee who simply makes repeated mistakes or is late or absent for non-willful or non-intentional reasons. Moving quickly now, because I'm conscious of the time, and I do want to make sure that we leave a couple minutes to answer questions that you have. We've included here some best practices for progressive discipline. They're not going to be surprising to you. Employers need to make sure they're setting clear expectations, the way that Avneet mentioned through, for instance, a staged and clear attendance management program. Document, provide warnings, do not jump to conclusions. And again, we want to make sure that the duty to accommodate informs our analysis here. And so the only thing I will say is that it is important whenever there are any disability-related needs or accommodation needs at large that are part of an employee's specific fact situation, before we move to terminate, we should seek counsel and really consider the risks from a human rights and wrongful dismissal perspective before we do that. Okay. I'm going to leave up our key takeaways slide here, but we wanted to take a couple minutes to address some of the questions that we've seen through the presentation so far today. I'm going to just kick it off because I saw a couple questions about the recent amendments to the employment standards legislation in Ontario and in Quebec under Bills 190 and 68. Respectively. Those bills, and we touched a little bit upon it, they do introduce additional prohibitions on employers from seeking doctor's notes and medical documentation to substantiate a leave of absence for the statutorily protected leaves of absence under each legislation. And so that's limited. That's fairly limited. Under the Employment Standards Act in Ontario, it is the first 3 sick days per calendar year that an employee takes off for personal illness or injury. An employer is not allowed to ask for medical documentation to support that. However, under the Ontario bill, employers are still allowed to require reasonable evidence in the circumstances to support that leave. From our perspective, the most simple one that we anticipate is an employee attestation, to simply ask the employee to attest to the fact that they are indeed absent as a result of a sickness. Those are going to be considered non-culpable absences. They are already protected by statute. And so that will limit employers' ability to, discipline or act based on those absences, but only for the first 3 days. And so we recommend employers always make sure that they are tracking the number of sick days that employees are taking so that they know when their ability to request medical information starts. And then under Bill 68 in Quebec, the prohibition does extend more than just doctor's notes, but to any form of documentation. And unfortunately, I recognize the challenge that puts on employers in Quebec. However, I do think that the legislation still provides an ability for employers to require employees to provide notice as soon as they can of their need for an absence, as well as the general reason for that absence. And so we would just encourage our Quebec employers to review their policies and seek legal advice for how they might be able to strengthen those policies within the limits of the legislation.
And I'm going to address two additional questions that came up. Again, they're along themes that we've seen both in your predetermined questions as well the questions today. Some of you have asked questions about what can be done in terms of discipline when an employee claims to be on a sick leave or other type of protected leave, but then it is discovered that they're working elsewhere or they're on vacation. Rachel touched on that a little bit, but what I wanted to clarify was that in these types of situations, you have evidence or information, let's say, that indicates that perhaps the reason for their absence is not actually medical or not, right? And so what are you supposed to do when that happens? The first step would be to provide the employee with an opportunity to respond to that additional information, right? You might learn stuff that explains the discrepancy. And depending on their answers, you may be able to discipline, provided that they cannot provide, a reasonable explanation for that discrepancy. But an employee may claim that the vacation, for example, that they went on was for medical related reasons. And so you would need to, once they do make that clear, then the obligation is on the employer to verify whether it is in fact for medical related reasons or not. And that would be with requesting medical information. And that way you would mitigate the potential human rights risks. The other theme that I saw in the questions was about the contents of the medical note, and it was about something that I had said about, what information can be and cannot be included in a medical note. And I should have been a little bit more careful about what I said in terms of what information we can and cannot request in a medical note. So the important thing to consider here is employee consent. If the employee is consenting to disclose information, for example, to an occupational health nurse about their diagnosis, then that would not be offside. If an employee provides a medical note and the name of their treating practitioner, if it's not like a GP, it's actually a specialist. And so as the recipient, you get a little bit of an idea of maybe perhaps what the medical condition is. Again, that would not be offside because the employee himself or herself or themselves are at disclosing that information. So keep in mind sort of this idea of consent. And then finally, just to piggyback on something that Rachel had said in terms of employee attestations as the reasonable evidence to substantiate an unpaid leave under the Employment Standards Act, the neat thing about that is that you could then, should you receive information that disputes the fact that it was for a sick leave, then you can use that employee attestation to question or provide an opportunity to the employee to explain why they had attested that something was for sick leave when there is information to indicate otherwise. So that would help sort of build that progressive discipline case and proceed to progressively discipline.
And finally, I'll just jump in to answer maybe two final questions. And I know this also came up in some of the questions that were shared prior to the presentation, but it's this idea of what to do if an employee has provided documentation to a third-party insurer who's been contracted or hired by the employer to adjudicate absences or in respect to maybe short-term disability absences, and I'll just use that as an example. I think it's important to understand in these circumstances that an employer's obligation is not absolved because a third-party adjudicator determined that the medical note doesn't suffice the ongoing absences. Those are, like we had mentioned before, they're contractual terms. It may be that it does, but there might be a situation where the third-party insurer said, listen, we deem this employee capable of returning, and the employee produces a medical note to the employer that says otherwise. And so while you can rely on it, there may be circumstances where an employer has to take on additional steps to ensure that they've done their due diligence to determine whether the accommodation process has been exhausted or whether the employee needs to be continued to be accommodated on an unpaid leave. Usually an insurer's adjudication of a file will be in terms of the actual language and eligibility criteria for the purposes of the paid benefit, not so much the need for the employer. The assessment isn't really taking into account the employer's need to accommodate to the point of undue hardship. I know it's a bit of a gray area because and as I think Tala or Rachel, I can't remember which one of you had said, there's the element of the paid benefit that could be adjudicated by the insurer, and then the employer's benefit to continue accommodating whether on unpaid or paid leave. So again, a lawyer response, it'll be really dependent on their circumstance. And this kind of leads to another question that's come out is at what point, whether it's 2.5 years or and a doctor keeps pushing back the return to work date, does the employer have you reached the point of that or the threshold for frustration? And again, it really depends on the circumstances. Typically, what we like to advise is that if an employee has been absent for 2 years and is unable to return to work, then you want to start asking types of questions from the medical practitioner that speak to whether the employee is able to return with or without accommodation in the foreseeable futures. That's usually the test that's applied to determine if frustration has been established. And so the idea is that if a doctor or you have a note 2 years into the leave that says this employee will not be able to return in the foreseeable future with or without accommodation, and you have a medical note to say this, then there's a high chance that you have been able to establish frustration versus a medical note that says this person's under a treatment plan. We presume that there may be improvement in their condition in the next 3 months following the end of this treatment plan. In that circumstance, even if it's been 2.5, 3 years, because that last medical note that you have on file opens up this possibility that this employee is able to return, you may not be able to meet the threshold for frustration. So again, it's a very case-by-case approach, and I appreciate sometimes we want clear-cut answers, but this is an area that's very much individualistic, and so unfortunately, those types of answers don't exist. But I think we're going to call it time here. I know we went 10 minutes over, so I'll let Tala kind of just take it away and conclude.
Thank you, Avni. Yes, we do appreciate you staying 10 minutes later than expected, but we did want to get a chance to provide you with all the information as well as answer your questions. So I'd like to thank all of you, our viewers, and my fellow panelists for joining us today. The link for the Ontario and Quebec CPD certificate is on your screen, as well as the HRPA. code. For our BC viewers, the Law Society of BC has been added to the chat as well. The final webinar in our fall series is on December 3rd. It is titled Collective Bargaining Year in Review. If you'd like to sign up for this event, the link has been added to the audience chat as well. If you'd like to register for any of our events or watch replays of previous events, please visit the events section of fasken.com. Thanks again for coming and have a great afternoon.